Welcome to Advocating for Dads with Jana Jones. In this empowering podcast, we delve into the world of fatherhood and custody rights.
Welcome to Advocating for Dads with Jana Jones. I'm Sam Henninger, and I'm really excited to jump into a conversation today with Jana. We're going to first start with something that we had been talking about in previous episodes, but we're going to pay special attention and get started with this conversation. And let me ask you, Jana, what factors are considered when determining the child's best interest in custody disputes, and how do parental involvement, stability, and capabilities play a role in that?
Yeah, so there are factors that the court is always going to consider when they're looking at best interest of the child or children. And I would say the biggest thing that most judges are looking for is stability. They're looking to see, is there appropriate housing for the children? Are there any issues with safety for the children? And then they're looking to see who's being supportive of the children's education, right? Is one parent or the other getting the child to school late, or is the child missing school altogether in their care? And then I would say the court's looking at the other tangible things like extracurriculars, support when it comes to, say, therapy or something like that. What parent is really working towards a harmonious co-parenting relationship with the other one? A parent who is facilitating visitation with the other parent is always going to be appreciated by a judge, because that's telling the judge that you recognize that regardless of why your relationship ended, the relationship with the children and that other parent is still important. So there are a number of things that the court is considering when they're thinking about best interest of the children.
Maybe you could share some examples of how parental involvement positively impacts a child's well-being during and after a custody dispute.
Being involved is just important. Does the parent want to spend time with the kid? When it's time for the child to go to that parent, is that parent actually getting the child? There are circumstances where you have a parent requesting time, claiming they're not getting time, and then when it's time to go, they flake. And that lack of involvement is definitely something that the court is going to take note of when they're considering what kind of custody schedule is going to be the most appropriate and in the children's best interest. How
do you work with parents to create personalized plans that address their unique family dynamics and prioritize their children's needs?
Yeah, so as I mentioned in a previous episode, I have a questionnaire that I have my parents fill out before we start drafting anything at all. So I can get a lot more details about what's been going on, what's worked well, what hasn't, what they think is their best evidence, which may or may not be, but I want to know their perspective on things. Sometimes things like specific religions and holidays are going to be really important. And, generally speaking, we think about average American holidays. When we're talking about the major holidays, most judges are going to go to Christmas and Thanksgiving. If you're Jewish, Christmas means nothing to you, right? That's not something that you're going to celebrate. So then the Jewish holidays are going to be far more important. So giving that kind of information, letting me know that kind of information helps me advocate for what it is that each unique family finds important, and each particular parent wants to see in a custody order.
Because it's come up, maybe you just spend a bit of time and walk the listeners through a bit of what that questionnaire looks like that you use.
Because I'm starting from the beginning, I don't know a lot of basic information. So the first thing in my questionnaire is going to go back to what we talked about in that previous podcast, which is the name and address of the opposing party, because we got to know who we're serving and we have to get them properly served before anything can really get started. The next thing that I'm going to really need is the names and dates of birth of each of the children. So it's very important to know that information, to have that spelling correct. I've seen cases where somebody didn't have the correct spelling of their own child's name. That doesn't look great in court. So you want to make sure that that information is accurate. North Carolina requires in our custody complaint and answer and counterclaim that we list where the child or children have resided for the past 5 years. That's called an affidavit as to the status of the minor child. So one of my questions is where, in fact, have the children resided for the past 5 years? Obviously, if you're dealing with a child that is under 5, then you're going to be dealing with birth to present. And then I'm going to ask, what kind of custody arrangement are you hoping to achieve? And I'm asking for specifics. Again, I want people to fill out my questionnaire like they're the ones writing the order, because I need that kind of detail to know what I'm specifically asking for. And when I'm drafting the consent order, that helps me be a lot more efficient in crafting an order that reflects what the parent actually wants. And then lastly, I'm asking for any evidence that the parent may have to support the custody order that they would like to see be implemented. So if they feel like the other parent has done something to put the child in danger, or is not getting the child to school on time, or has done something inappropriate to the child, that's the kind of information that I need. And if there's evidence that backs that up, that's when they would give me that information.
My mom and dad split up, and then my dad moved out of state. And so me and my sister got to visit him during the summer. And that's, I guess, maybe one arrangement that parents and kids come to there. But maybe you can offer some of what you've seen when it comes to creative solutions or strategies that you recommend for long distance parenting and arrangements that involve technology assisted visitation. I know that FaceTime and Zoom are a lot more prevalent now, but all with the intent to maintain a strong parent-child relationship.
Yeah, exactly. That's what you're trying to do, is to maintain that relationship regardless. I'm thinking about some of my folks in the military that I've represented on custody cases, and that can be particularly challenging, right? They don't get to choose where they're going, and they aren't choosing to be away from their children. They are called to a higher purpose, and they have a job to do. And that job might take them across the world. And so technology, thankfully, really gives you a chance to still foster that relationship. So for parents that are far apart, that communication provision in an order is going to really be important. Obviously, it's not meant to control the custodial parent's life, right? They still have things going on. They can't just drop everything for calls or FaceTimes or Skypes, etc. But to have something in place where everybody knows what the expectation is, and to give that child time to, foster that relationship with the parent that's far away is really important. And the fact that we have the technology that allows us to do that, we really want to take advantage of that. When it comes to the physical custody arrangements for parents that are far apart, generally speaking, somebody's going to have primary, somebody's going to have visitation. Once you get children in school, if you're living, one parent's on one coast and the other's on the other, a joint custody arrangement's just not really going to be practical. The closest way you can get to that is probably holidays and then like an entire summer. And that may or may not be practical for the family, right? Obviously, the parent who has the child during the school year wants to have some fun with them during the summer too. So it wouldn't necessarily be fair to take all that time in the summer. But that's probably the closest way to get to some semblance of a joint custody arrangement when parties are that far apart.
What other common challenges do you see parents face when it comes to navigating these visitation arrangements, and how can legal counsel help address these challenges effectively?
Well, I think the biggest thing that I do as an attorney is give people facts, right? I'm not emotionally invested in the situation. I haven't been hurt, or I haven't hurt the other party. And so I can be much more objective in evaluating what is and isn't likely to work in front of a judge as it relates to what kind of custody schedule is going to probably be what the court feels is in the best interest of the child or children. So I think that's the most important thing that an attorney can do, is to give you that unbiased factual information. And then you take that back with obviously a lot of emotions that come with co-parenting and figure out how you want to move forward from there. How
do you handle conflicts such as, I'm thinking about non-compliance with visitation agreements and denial of visitation or attempts at parental alienation?
So when it comes to a custody order, each party is supposed to follow that order. And if you have violated a provision of that order, then the offending party can be found in contempt. But you have to file a motion in order for a judge to make a determination as to whether or not there has been willful noncompliance with a provision, if they can find them in contempt. There are a couple different types of contempt. There's civil and there's criminal. I won't go into all of that because it'll probably bore your listeners to death. However, to kind of make it simple, there has to be a specific provision in an order that someone is violating in order for the court to find them in contempt. Now, before you're even going down that road, the pro to having a custody order is that you can get law enforcement involved to help execute that order. So say, for instance, a visitation happened and one parent was supposed to get the other child at 6 p.m. on a particular day. 6 p.m. came and went, and the party didn't show up to the exchange location. You can reach out to law enforcement and ask them to help you get your child back because you have a custody order that says that you're entitled to that time with the child. So that is the power of having a custody order, along with the fact that after the situation happens, you have the ability to punish the parent who has violated a provision by asking that they be held in contempt of court.
And so I'm hearing a lot of make sure you have a good plan. Make sure you have, well, if you have that, the order, you have ways to enforce it, which I think perhaps a lot of people might worry that great, I guess the court made a decision, but what happens when the other party doesn't follow through?
Absolutely. Yeah. Any order is going to be enforceable by the contempt powers of the court. So you have the ability to go into court and ask that the judge hold that other party in contempt for failure to comply with the court's order.
I'm just curious, what does that timeline usually look like when filing that motion and getting a decision?
So the motion is just as long as it takes to get it drafted and filed, right? The question is, when do you get a court date? And that is something we don't know. Once we file, it goes to family court and eventually makes it to a judge, and they put a date on it and they tell us what it's going to be. Sometimes that'll be within a few weeks. Sometimes it'll be within a few months. There are so many things that come into play with how quickly you can get a court date, but the majority of them have absolutely nothing to do with the parties or the attorney. That is the inner workings of family court.
Then I'm sure you'd understand. I mean, you know this better than I, but my first thought then would be if there's cause for one motion, there might be cause for more than one motion before a court date gets set. And so do you see that happen?
Yeah. And so when it comes to everything in this country with the legal system, it's about notice. As I've said in some previous podcasts, you got to have service, you got to have notice before anything really gets going. And it's the same thing with the contempt. So the judge is going to look at the four corners, we call it, of your motion for contempt. And everything that you're alleging in there is up for grabs as a potential finding for contempt. But things that are outside of that, meaning things that may have happened before that you didn't list in the motion, or things that have happened since you filed the motion, are not going to be a part of that court date. You can file an amended one potentially if, time allows for that. But otherwise, assuming you get a court hearing before any type of amended pleading has been filed and the other side has been given proper notice of it, then you're going to be going with the motion that you filed originally. You can file subsequent motions. But one thing I want people to always know about contempts, it can be a vicious cycle. Because let's say, for instance, we file a contempt action. The party gets found in contempt, and let's say it's civil contempt and they have to pay attorney's fees because the court says this is something that shouldn't have happened. You have the ability to comply, and I'm going to make you pay the attorney's fees because of it. That party doesn't pay the attorney's fees. What do? Now you got to file another contempt on that order saying they had to pay attorney's fees. So it can become a vicious cycle. And generally speaking, unless the facts are particularly egregious, what I have noticed in my experiences is the court doesn't put folks in jail, not the first time around. It has to be pretty bad for them to do that. And that is what you're facing with the contempt. You are facing jail time, but it is unusual for that to happen the first time around. So unfortunately, what you find yourself in a lot of times is this revolving door before anything happens that makes that person feel like they've been made whole. And that can be a lot of anxiety, angst, court dates, and money to get there.
Given your role in this entire process, which has its place, but you're not necessarily getting much involved with the lives of people outside of these particular activities. And so what I'm hearing you say is your best friend in these situations is going to be a clear plan.
Absolutely. Yeah. And just because it can be litigated doesn't mean it should be, right? You got to weigh your pros and cons. It's that kind of return on investment that you want to consider. Is it worth the expense financially? Is it worth the stress of the court dates? These types of cases, contempts, can have ramifications with the children, right? So if you're trying to put mom or dad in jail, how's your child going to feel about that? How's that going to affect your relationship with your child? There's a lot of considerations that parties need to do some soul searching before they go down that road. And then you need to be prepared to maybe do it a few times before anything really sticks.
Jana, what concluding advice would you feel called to give to our listener, given that these can be some pretty sticky situations, but you're here to be of service to them in the way that the law provides? So what advice might you give them in conclusion?
I would say in conclusion, the law cannot fix everything. Again, the law cannot litigate your ex into being a better person. They're not going to change them. You need to understand the role of the law, right? Is to put guardrails up. I kind of think of it like bowling, right? You put those little things up that keep you from going into the gutter. That's what the law does. The law does not guarantee a strike. It guarantees that the ball doesn't fall in the gutter. And to the extent that you and your ex can work together to try to figure out some common ground, do so. Because you may end up in court with an order that neither one of you is happy with, because a neutral third party has made a decision about your lives. So to the extent that you're able to consider those things before you get into litigation, and then once you're in it, to know what is realistic, that's probably the most important piece of advice I can give.
Jana, thank you again for this wonderful wisdom that you give us and the expertise that you share as an advocate for dads.
Absolutely. Thank you so much for having me, Sam.
This has been Advocating for Dads with Jana Jones. I'm Sam Henninger. Remember to subscribe, share, follow, because we're going to continue having these great conversations with Jana. Thanks again.
Thanks for watching. If you like this video, don't forget to hit that like button and subscribe to our channel for more amazing videos like this one. And be sure to follow us on social media.